Hello guys, and welcome to another episode of my lecture. On today's episode, we'll be talking about appointment of directors. We have the first appointment, the subsequent appointment, as well as the casual appointment of directors. So without further ado, let us go straight to the class. So while we are talking about the appointment of directors, it is very important for us to look at section 2691 of Cama. Do not forget that while I was talking about the types of directors, starting from de jure director, de facto director, as well as shadow director, I told you that de jure director comes directly under section 269 of Cama, where it talks about persons who are duly appointed. So when we are talking about de jure directors, persons who are duly appointed, how then can we say that they have been duly appointed? Before we talk about that, let's go to section 271 of Cama. It tells us that every company, not being a small company, shall have at least 2 directors. What does this mean? It means that every company must have at least 2 directors. Now, there are 3 types of appointments. We have the first appointment, the subsequent appointment, and then the casual appointment. When we are discussing about the first appointment, we need to go to section 272 of the Cama. And what does the provision of section 272 of Cama, what does it tell us? It tells us that subject to section 271 of this act, the number of directors and the names of the first directors shall be determined in writing by the subscribers of the memorandum of association, or majority of them, or the directors may be named in the articles. 3 things. Number 1, it can be determined in writing by the subscribers of the memorandum of association. Number 2, or majority of them. And number 3, the directors may be named in the articles. For the number 1, when you go to section 42, upon incorporation of a company, you have to read it in line with section 36(4)(c) that says that amongst the application to be submitted by the company for incorporation of that company must be a statement of the company's proposed directors. That explains better the first one that says that the first director is determined in writing by the subscribers of the association. The second one says by majority of them when they come together to appoint directors, or the directors may be named in the articles. Now, when we are talking about subsequent appointment of directors, then we are looking at section 273 sub 1 of the Cama. And what does section 273 say? It says that the members at the annual general meeting may re-elect or reject directors and may appoint new ones. This provision expressly tells us that the power to appoint director is in the hands of the members in general meeting. A director cannot be appointed except through the members in general meeting, as we can see in section 273 subsection 1 of Cama. For there to be such, it has to be in line with the ordinary resolution as passed in section 258. Section 258(1) of Cama. It should be noted that the general rule is that the members in general meeting are the ones to appoint, re-elect, or reject directors. However, there are certain exceptions to that, and I will get to those exceptions later in my lecture. Moving on to the third type of appointment of directors, we have the casual appointment of directors. Now, when we are talking about the casual appointment, we have to go to section 274 subsection 1 of Cama, and it tells us that the board of directors may appoint new directors to fill any casual vacancy arising out of death, resignation, retirement, or removal. Now, I told you when I was talking about section 273 that there are certain exceptions to the rule that the members in general meeting, that is at annual general meeting, may re-elect, reject, or appoint new directors, and one of those exceptions can be found in section 274, where the act stipulates 4 grounds for the board of directors to appoint new directors. The first one is removal, the second, resignation, the third, retirement, and the fourth, death. Where any of these come about, then the board of directors can appoint a director. Now, when we are going to subsection 2, it tells us that where a casual vacancy is filled by the director, that's in subsection 1, the person may be approved by the general meeting at the next annual general meeting, and if not so approved, he immediately cease to be a director. Do you understand that? It means that when a person has been appointed as a director by section 2741, that is through the board of director, yes, for that time when he is appointed, he is valid, he is a de jure director. But his de jure directorship must be confirmed in the next annual general meeting of the company. If he is rejected at that annual general meeting and his appointment is not affirmed, then he immediately ceases to be a director. But if he continues to direct and manage the business of the company after such rejection, after he wasn't affirmed, then he would still be a director instead of director de jure. As we could see when he was appointed by the board of directors, he became director de facto. Do you understand? Subsection 3 of section 274 tells us that the directors may increase the number of directors if it does not exceed the maximum allowed by the articles. But the general meeting may increase or reduce the number of directors generally and may determine in what rotation the directors shall retire, provided that such rotation shall not invalidate any prior act of the removed director. Now, in order to understand this third subsection, it is very important for us to pick it segment by segment. So let us start with the first one that says that the director may increase the number of directors if it does not exceed the maximum allowed by the articles. What this means is that when it comes to casual vacancy, directors may increase the number, but such casual vacancy is subject to confirmation by the members in general meeting in the next annual general meeting. Do you understand that? However, such increase in the number of director must be in line with the article. Where it is higher than the number stipulated in the article, then we all know that that will be void because it is contravening the article, which is the constitution of every company. Now, the second part is that general meeting may increase or reduce the number of directors generally, which means that when the general meeting want to increase, they can do it if they want. However, it should be noted that where the article specifies a specific amount of people to be directors, the general meeting cannot exceed it except they alter the articles. Until they so alter their articles, they cannot exceed the number of directors to be appointed. Do you understand? Now, the board of directors, on the other hand, they cannot alter the articles. The power to alter the articles is in the members in general meeting. So, as we can see, the members in general meeting may determine also in what rotation the directors shall retire, provided that such reduction shall not invalidate any prior act of the removed director. Which means when they remove a particular director, while he, that is the removed director, was acting as a director, his act while he was acting as a director will still be valid. The removal does not invalidate his act when he was acting as a director. And then lastly, in this particular lecture, we will look at section 276, which we have interrogated in my previous lectures, but just for the sake of it, liability of persons not duly appointed under section 276 of Cama. It tells us that when a person not duly appointed as a director act as such on behalf of the company, his act does not bind the company and he is personally liable for such action. But where it is the company which holds him out as a director, the company is bound by his act. Well, we've explained this in the last class and what it means. Where a person acts as a director of a company where the company doesn't have knowledge that he was acting, he will be personally liable. But where the company has knowledge, then the company would be liable for his act, and his act shall bind the company. When we are talking about appointment of directors, we've spoken about the casual appointment, the first appointment, the subsequent appointment. When all these appointments are made, then they are de jure appointments. Do you understand? In my next lecture, I will be interrogating sheer qualification of directors. See you in my next class.